happen all over the United States. It's not just confined to Williamson County. It's everywhere. But I'm anticipating, based on the information that we've surmised from the audit that we conducted, which the results are there, out of 1,576 documents, it pretty much is a good cross-section that over any time that MERS is involved, if we were to pull the entire scenario of MERS-related documents, the notes were probably sold before they were even recorded. And 192.007 says that when you record the first document, you must record every subsequent document thereafter, affecting the original deed of trust document. I don't think there's any dispute on that. But the problem is that MERS seems to think that they're above the law. In fact, when the media, I understand, contacted MERS and had never even seen this audit, said, quote, "You haven't done anything wrong." Why would you say that? Most people would say, well, we haven't seen the report, so we really can't comment on it. So this is not atypical of MERS's behavior, because the idea here is to keep MERS in the game and its member subscribers in the game as long as they can, as long as the counties are willing to allow them and their officers who have no regulatory oversight to come in and misbehave and trash the land records. This is all by design. And I welcome any questions.
Give Ms. Reister some credit here. I know she's been working on this for 2 years at least, because I've been on some conversations with her and so forth, with Dallas and so forth, and I think she's been working on it very hard. Where are we with the lawsuits? What action has been taken? Are we involved in any at this point?
We're not involved in any at this point that I'm aware of. Dallas County just in the last few weeks has, it was ruled not to be a class action.
It didn't make the class action.
Because enough counties did not
Sign up
and at Breeze and say, yes, we want to be a part of this. Because so many people are standing either doing the lawsuits on their own, like Travis County, Bear County, El Paso, which El Paso has already been dismissed. People are trying it on their own, and it's one of those united we stand, divided we fall. And they still would invite our participation.
Let me say, one of the reasons that I've been interested, I know Ms. Reister's been interested in it, is no doubt that there's some loss of revenue to the county. That's probably true. But our real reason to be in there is because of the loss to the landowners, the homeowners, and so forth, how they are not able to keep up with their business. That's, to me, is the most important thing. The fact that we get $1, $10 for filing a piece of paper is one thing, and I think that should happen for sure. But the main thing is the public is really being hurt in this. I'm sorry.
Last summer, I had both the county attorney and the district attorney's office come down and take a look at before they even came. Because we had pulled up documents and had stacks of documents with variations of like a dozen different people who had signed and how odd their signatures were because they were not all the same, and showed that to them. And at that time, the DA's office said, well, it's just a misdemeanor on the notaries, so, you know, we really don't have a white-collar crime unit that can deal with this. The county attorney's office looked at it and said, well, that's interesting, and walked away.
I really think, it's my opinion, this is bigger than Williamson.
Yes, it is.
It's something that we're going to have to be in a group, or we're not going to be a big national, international company.
If you're one of the property owners that's affected by this, what is the next step?
I'm going to answer that in two parts. Most property owners right now are trying to get their head around this mess in the first place. I've distributed a number of books, been on a lot of talk shows, And the types of talk shows I'm on are the types of talk shows that cater to the fringe out there that is woken up and is looking at this stuff for the first time and saying, this just isn't right. What I'm trying to do, as I expressed to the county clerks back in College Station a year ago, January, is I'm trying to avoid seeing the county get sued, because homeowners do not understand that the onus is on the clerk to record every document she's presented with. It's not her fault. We're the good guys here. So because of the fact that everybody's affected by all of this, the only, the homeowners left in a quandary are stuck with the court systems, and they're in there saying, well, we don't know what to do. I'm also trying to discourage them from filing these Patriot-style documents in the land records, which now California is putting several people away in prison. One woman got 2 consecutive one-year terms for filing erroneous documents and fraudulent Patriot-style documents in the land records to thwart the sale of her parents' home in foreclosure. And so she was sentenced by California in Stanislaus County to 2 one-year consecutive terms. 3 more couples have been indicted on similar charges, and they're going after a whole network of people that religiously are filing these administrative processes and things in the land records, trying to stop it. I had one case in Bastrop County where a woman was discouraged by not even the clerks in the county clerk's office, but also was discouraged by onlooking bystanders that were going, oh, you shouldn't file that in there. This affidavit and all these quick claim deeds, you shouldn't file that in there. You already got a trustee's deed on the property. It's already been sold. You're slandering title to the property. She went ahead and did it anyway.
Forgive me, I am an advocate, but
I understand.
I'm still not clear in what you're saying with the homeowners that do it this way.
A lot of people right now are filing quiet title actions. That's pretty much what a lot of people, want to do. The problem is we're also seeing, Commissioner Berkman, a lot of people that their chain of title is so distorted. We're not even sure. We have instances I reviewed where the homeowner, he had 2 pieces of property, and that story's in here to Jeffries. They had 2 pieces of property. They sold one, and the trustee that prepared the documents liened his own personal residence, and this happened for 4 different deeds of trust that were done in refinances. They took the same legal description, was not the legal description of the house that was sold. It was his own residence, and they proliferated it through the entire chain of title, and then after all was said and done, they realized, oops, we made a mistake, and so 4 robo-signers came in and recorded documents releasing all those deeds of trust. The quiet title is about the only way that we can have a remedy, but if your name's not on the warranty deed, or the warranty deed is corrupted, which we have seen, that has happened because of this sloppy preparation that seems to have occurred between 2003 and 2008 before the crash. There was a big rush to get paperwork out, and a lot of mistakes were made, and these are some of the things that we're seeing now that are coming back to haunt us. And so homeowners, a lot of them just don't have the money, for starters, and a lot of them are just walking away from their houses doing what we call strategic default, and I talk about that in the book. But quiet title right now is about the only formidable attempt other than litigating and doing affirmative defenses in foreclosure. And to the second part of the question, I want to introduce David Rogers, who is the attorney that rendered the opinion letter for this audit. I'm going to let him address your other questions.
Judge, please, the Commissioner's Court.
Please state your name.
My name is David Rogers. I'm an attorney, live in Pflugerville, and I practice in Austin, Williamson County, and in Hays County, primarily occasionally in Bergen County. What I do is homeowner defense. So I am neck deep in these legal issues. To answer your question succinctly, Commissioner Berkman, the answer is I find a lawyer and talk to them about the problem. MERS, according to their own press releases, their own website, is involved in more than 70 million mortgages in the United States. If you have taken out a mortgage in the last 10 years, the odds are very high that MERS is involved. This seems like it must be a simple area of the law, but and that's what I thought when I first started doing it. But it turns out to be quite complex. The opinion letter that I have attached here, and I'd ask you to turn to page 145 in your audit book. I'm sorry, 143. Talks about what MERS is. Because I think that is a simple question. MERS is a problem. What kind of problem is MERS? There are a number of courts that have looked at what MERS is. In addition to the court opinions that I have excerpted there from the Washington State Supreme Court, from a New York State Appellate Court, from the Kansas Supreme Court, from a Missouri Court of Appeals, from the Nebraska Court of Appeals. I also have at the end of that section, beginning on page 50, something called the building blocks of MERS, and that is taken from MERS' own documents about what they say they are. Because Williamson County is such a hotbed of high technology, Dell being centered here, I thought maybe a technology analogy might be a helpful place to start with this. Does anybody here know what a beta test is? A couple of guesses. MERS is something that should have been beta tested. It was released to the general public before all the wrinkles were aired out. The laws of every state are different with regard to reporting. What has to be reported, what doesn't have to be reported. MERS is designed as a centralized national database. It does not take account of all of the differences in the laws of all of the 50 states. We heard some discussion of Local Government Code 192.07 earlier. The clerk, Reister, talked about that, and I've got that excerpted on page 147 in the footnote at the bottom. To release, transfer, assign, or take another action relating to an instrument that is filed, registered, or recorded in the office of the county clerk, a person must, not may, must file, register, or record another instrument relating to the action in the same manner as the original instrument was required to be filed, registered, or recorded. What that means is the MERS business model is illegal in Texas. This requirement is that every time there is an assignment of the deed of trust, which is what MERS does, right? They transfer the ownership of your notes and your deed of trust left, right, and center, but they don't record it in the county deed records. Local Government Code 192.07 requires them to make that reporting, and they don't do it. And this was enacted by the Texas legislature in 1989 as a global cleanup of all of the reporting statutes. There were a variety of reporting statutes at the time. Some things had to be reported in one place, some things had to be reported in other places. It wasn't clear how they were going to do that going forward. The legislature looked at this and said, we need to have a single repository for all the records that get reported. We're going to do it all in the county clerk's office, and we're going to mandate that every time we change the ownership or change anything related to the document, you have to record it. There's been some discussion about trustees earlier. Now, most people, I didn't know this before I started getting into this, so I assume most people didn't know. When you